Alex here with part 55 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. The second thing is that the underlying purpose of this series, in a nutshell, is to provide my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. I also like to go ahead and mention every fifth video just to remind people that if you're not getting all of the updates on the My Docket series, it is likely because you are a subscriber but you have not clicked on the bell notifications button. If you'd like for YouTube to email you each and every time there's an update to the channel, all you have to do is click on the bell notification button, and that will go ahead and signal to YouTube that you're not just looking for the highlights, you're looking for any publication or any update on the channel. I remember my mindset very clearly even today. The first time I filed an appeal, I felt a tremendous amount of anxiety about it all. I had no clue how it was going to work. The idea of being in the Supreme Court of Nevada was an impossible idea. In fact, I suspect that I would have never filed an appeal had I received some kind of detailed response from the district judge on why my petition was denied. I would have probably felt like, okay, I'm not going to get anywhere. This order makes sense, even though I don't agree with it, even though it's unfair. I have strong suspicions that it was the judge's 2-paragraph response that really gave me the surge of emotion that I needed to just try to right a wrong. In my opinion, a 2-paragraph order denying made no sense at all, and it was very inconsistent from what I'd seen throughout the case, well, throughout the other cases, through my child custody action with District Judge Chuck Weller, and also the brief involvement I had with the domestic master in, I think it's parts 1 through 9 for the most part of the My Docket series. I always felt like even if I didn't get what I wanted, I had a detailed enough explanation for me to feel satisfied that I had a fair shake in court. Yet with this judge, District Judge Stephen Kasach, it was that 2-paragraph order that I have a strong suspicion gave me that it pissed me off. I don't know how else to explain it. And so I filed the appeal. I still lost the appeal. It still wasn't a good idea to file an appeal just because I was pissed off. But when it comes down to it, even though I lost the appeal, it kind of showed me that this process, while difficult, is nothing to be afraid of. And it kind of made it easier for me to file new appeals going forward. And in fact, I don't even know how many appeals I filed to this day. I think somewhere around 8 or 9. But once you go through the process once, the next time around, it gets a whole lot easier. And it's not even just the work, it's also the emotional and mental preparation to file an appeal, to get into the Supreme Court. And it doesn't seem so distant anymore. I think to an ordinary person, the thought of going to any court at all is frightening. And the thought of going to a Supreme Court anywhere is just an impossible idea for most people. But at this point, I had the experience. I'd gone through it. I got the experience from litigating an appellate action. And so even though I did it for the wrong reasons, it ended up being a benefit to me in the future anyway, because I was going to end up having to go back to the Supreme Court on multiple occasions, and I do eventually win not 1, not 2, not 3, but 4 appeals. So it ended up being what I needed. And I think at this point we can actually go ahead and take a look at what I have filed. Here we have my civil proper person appeal statement. So this is one of those forum documents that the Supreme Court mails to any self-represented party that files an appeal, at least in the state of Nevada. I stopped using these after I think the second time. I would take them and just throw them away, and I would write up my own documents. But that's not necessarily something that everyone should do right off the bat. I do recommend preparing your custom papers and pleadings. It does get you sort of you get treated more seriously by any judge, not just the Supreme Court of Nevada. But if you have no clue what's going on, if you don't know how any of the pieces to the puzzle work, it might not be a good idea to try and do that. In fact, it could be something that backfires on you if you just overlook something. So you might want to consider using one of these self-help forums. That's what I kind of call them. If you get these from your Supreme Court or whatever court it is you're appealing to in your state, or even if you're in Nevada. But I do want to let my viewers know that while you're doing something like this, always keep in mind that you need to learn. Always keep in mind that you might have to come back to the Supreme Court again. There's this idea that a lot of us have, which is, I hate this, I hate going to court, I hate the Supreme Court even more because it's going to be even harder. And so since I hate all this stuff, I can't wait to be done with it and I'm never coming back. And that kind of mentality kind of shuts off those learning juices. You just want to get over it. You just want to get through it. You just want to get done. And you're not really in this mode where you're trying to absorb as much as you can. And that's really what you need to be in with these high conflict child custody cases, because they don't end. They go on forever and ever. So definitely adjust your mindset if you are going to use one of these self-help forums. And keep in mind that you do ultimately one day need to get to the point where you can prepare custom briefs in the Supreme Court. Because, as we all know, the family divisions of our courts aren't necessarily the most competent divisions or the most competent judges when it comes to, comparatively speaking, the entire judiciary. And so we are in the situation where we're probably going to be more likely than any other litigant in any other type of case to be subjected to a mistake or a legal error that needs to be corrected on appeal. So keep in mind that by being in the family court, you are more likely than an ordinary litigant to be subjected to some kind of mistake, legal error, abuse of discretion, etc., etc. So again, this is the civil proper person appeal statement that I received in the mail from the Supreme Court of Nevada, and we're going to go ahead and look at this. I haven't looked at this prior, so I don't know what to expect, but it's going to be one of those fill-in-the-blank forms. The first page here just indicates who I am. On the left, the appellant, and my name and address. Again, this is all old information, guys. I don't care if anyone knows anything about this stuff. It's 10 years old. And on the right-hand side, we have the government's attorney, which is Charles Wayne Howell. Scrolling down. We have the civil proper person appeal statement instructions, and if you really want to read through these instructions, you can go ahead and do that. I'm going to, as with all my previous documents, include this down in the description below. Just click on the link to download it, and if you have any questions, you can go ahead and post it down in the comments below. But for the most part, I want to move on to what I've actually done, rather than go through the Supreme Court of Nevada's instructions on what to do when you get one of these self-help forms. Oh, one more thing I want to mention. There was a time in the Nevada Supreme Court when they had a rule of appellate procedure that actually forbids a non-attorney from using anything but this form unless you get permission from the Supreme Court. Now, to give them credit, as far as I know, anyone who asked for permission to file a custom paper or pleading in the Supreme Court of Nevada was granted permission to do so. They only made a big deal out of it for people who didn't ask for permission and tried to do it. Later on, they just got rid of that rule, and they said, file what you want. You can file an opening brief if you want, or you can use our self-help form. You don't have to ask for permission anymore. Scrolling down. Okay, so here, yeah, this is a self-help fill-in-the-blank type of thing. The judgment or order that I am appealing, and I indicate here the date that it was filed, and I name the judgment or order. The notice, the date that I filed my notice of appeal, and this is the date that it was filed. You know what? This actually looks, it looks like they combined the docketing statement with the brief. I'm going to give a more clear answer when I get towards the end of this. I'm not sure. But these things here, where you identify the judgment, the date that it was filed, when you filed the notice of appeal, the related cases here, which is basically other cases. This type of information is docketing statement information. And a docketing statement, I don't think I prepare one in this case. It looks like this is taking care of it for me. A docketing statement in an appellate court is going to indicate the kind of bullet points as to jurisdiction in the appellate court. And the reason I say jurisdiction is because it's not just when the order was filed and when you appealed it, because as you can see, they actually went over it in this document. It's also other quirky things like what was it that you were granted or denied? What are particularly the issues that are being brought up? Because there's also jurisdictional issues as to whether the particular thing that was denied is appealable. And my understanding of the docketing statement is that they want to review all of those bullet points to determine whether or not the appeal should be dismissed straight away. It's not the point of a docketing statement to prove your particular case at that point. It's just the point, my understanding from what I have looked at, the point of it is not to say, hey, I should win my case right now because of what's in this docketing statement. It's, hey, you should have the authority to review this case because of what's in this docketing statement. And then later on in the appeal, you'll be filing your actual briefs. And at that point, you'll determine or you'll argue why you should win the appeal. But from what I'm looking at here, issues and appeal, statement of facts, all of these things are in the docketing statements, the formal docketing statements. So it looks like I did prepare a custom one. This can't be right. Oh, no, I didn't. Did I? Hold on a second. I did. This is an opening brief that I just stapled to the back of their custom form. All right, so that answers my question. Okay, so this civil proper person, what do they call it? Appeal statement is a combination of the docketing statement and the actual arguments as to why you should win. And what I did was unstaple the portions of it that actually went into the brief, and I typed up my own opening brief and stapled it to the back of it. So it looks like the first section of it, which is mainly the docketing statement questions, when was stuff appealed, when was this order filed, etc. Those were the first few pages. And then the briefing part, which is supposed to be something that happens later on in the case, for whatever reason, when it comes to self-represented parties, they just lump it all together into one packet. That stuff I decided not to fill out by hand and fill in the blanks, and I just unstapled it and stuck this to the back of it, and they went ahead and filed it. It's a little odd. I wouldn't be surprised if they didn't get upset. I don't think they do in this case, but I'm pretty sure I do this on my second or third appeal, and they do tell me to stop doing that. But I don't know. I don't want to tell my viewers to do something like that. Either prepare everything in the custom document. Either prepare everything in the self-help document that they give you, or go ahead and prepare your custom papers. Don't do something like half and half where you use their self-help document and then unstaple sheets and staple your own in the back. It's just going to confuse and annoy them. So here we have the actual opening brief itself. And this is normally a document that would not be filed right away in an appeal. It would usually be filed several months later. But I went ahead and filed it with the docketing statement right away. And I don't recommend doing that because you're going to need to do typically a tremendous amount of research to brief the appellate court on why you should have that decision of the lower judge reversed. But as we've seen in especially a number of my earlier videos in the My Docket series, I was constantly in a rush. I constantly wanted to get this stuff filed as soon as possible, usually within 2 or 3 days of deciding I wanted to fight something. And it's not something that I figured out until much later, where I start to actually take advantage of the time that I have and actually do some real research, some detailed research into the issues that I'm trying to get brought to the Supreme Court's attention. But it hasn't happened now with this particular document, so we're going to go ahead and go straight into the brief since that's what I prepared. So the statement of, memorandum of points and authorities, that shouldn't be here. So this is this is something that like goes into like a motion, but this is more like an opening brief, not a motion. So that's typically not something that would get put in there. It doesn't matter, they're going to ignore it, but it does look goofy. Okay, so the statement of issues is the first section where, and by the way, this particular phrase, statement of issues, the fact that this is required is not just something that I just decided to put in here. In the rules of appellate procedure, when you look under what's required in a brief, it actually specifically lists quite a few items in there, and one of them is a statement of issues, and as you can see looking a little further down, case statement, that's another one. There are I think like 8 or 9 of these different items that they expect to be included into these briefs, but the statement of issues is just a brief explanation as to what issue needs to be decided by our appellate court. And here I am bringing to their attention that statute 217.462, and I'm asking the Supreme Court to determine whether, pursuant to this particular law, a protective order is to be considered evidence of domestic violence, requiring the review of the substance behind the orders before actually assigning a fictitious address, or whether the issuance of a protective order in and of itself is enough to declare the applicant of the order a victim under the law. And this is actually the valid point. This does eventually result in a publication. It's not going to happen in this appeal, but it will happen in the next one that I bring to their attention. Case statement. This here is supposed to just be a very brief sort of background as to what's going on in the case. Typically, it's 1 or 2 paragraphs. It's not supposed to go into every little tiny thing that occurred in the case. So I'm indicating that I have the right to know where our son resides. I'm indicating that the district court had stated that as a general rule, I have a right to know where our son resides. And my ex has a fictitious address. And we share a common minor child, which is supposed to buttress this idea that I have a right to know where she resides. Because if you think about it, how could you claim you were aggrieved if you didn't know where or some other person resided? Nobody really has a right to know where anybody else resides just automatically. And I'm trying to state that since we have a common child, I do have a right to know, because that kind of factors into raising a child. So that is an important fact to bring up to the Supreme Court. We have another statement here where we share joint physical custody, and I'm also telling them that there's an order of protection that had issued. It's already long expired, but it did issue. And it's a good idea to be candid with the Supreme Court of any Supreme Court. Be candid with them. Don't just leave things like this out, even if it doesn't sound good. They need to know all the facts. And if you don't bring something up, your opponent is going to bring it up, and it's not going to look as good as it would if you were just, straight up with that court and just let them know, yes, this was entered against me, and this is actually part of the equation. This is part of the process, or this is part of, I guess you could say, the debate between both sides. And put stuff like that in your brief if it's relevant to what's going on, what you want reviewed on appeal. Don't leave things out that you don't like or that make you look bad just because you don't want to look bad. So if it's part of the law, if it's part of the case, put it in there. A Secretary of State issued a fictitious address. I petitioned the Second Judicial District Court for a judicial review hearing, and the Secretary of State opposed that. Here's the grounds that they used to oppose it. I'm not sure that this amount of detail needs to be in the case appeal statement, but it's there because I didn't know. I was probably just making sure. And the judge declared that the government basically didn't abuse its discretion when it issued the address, and that therefore judicial review was denied. Section 3 here, which is the argument. And now this is where all the detail's supposed to be. This is where citations to law, rules, case law, all of the relevant points as to why you should win should be in this section. This is the one that's not supposed to be a brief summary. It's supposed to go into all of the areas of the law that actually need to be addressed by the Supreme Court. So I want to just mention one more thing to my viewers. At the time that I filed this, we didn't have a court of appeals. So the Supreme Court would review anything that was brought to their attention from the district court. And I know I mentioned, I think it was in the previous video, that we have a push-down model and that things go down to the Court of Appeals. But that doesn't happen yet, because at the point in time that I filed this in 2010, we just didn't have a Court of Appeals. So it looks like I am bringing up the fact that the district court stated, without any details, that the government's argument, and what did I say here? Without any details, the decision to support the government's argument and no hearings or trials having been conducted, I'm going to just argue the case de novo before the Supreme Court. I don't know why I'm saying that. De novo just means all over again, like a do-over, and that they shouldn't get any deference. I guess in a way that's true, because there wasn't no evidence was taken by the lower court, so there wouldn't be any deference on the facts. And when it comes to law, questions of law are reviewed de novo. So maybe I had done a little bit of research and I figured that out. I should have put a citation there, but I didn't. It's a good idea to put citations in pretty much every single assertion that you put before the Supreme Court, because if you don't, they will often ignore it. They won't even look into what you're asserting if you haven't supported it with authority. This is one of the things that goes to their kind of fundamental bedrock principles of review. So it doesn't matter that I didn't cite a specific case as to what I was talking about, but when you're going into anything beyond that, you want to make sure that you find something to cite, whether it's a statute, a rule, or another case. Next, we have the Secretary of State's argument opposing judicial review. I'm asserting that they are legally sound by technicality. They fail to truly evade the Secretary of State from the scrutiny of this court. When there's a defect in the law, and the law mandates a particular thing, the Supreme Court can issue a writ of mandamus as an equitable remedy. This is true, so I finally figured it out. I still can't do it this way. I figured out that what I need to do is bring a writ of mandamus, but I didn't do that. I brought an appeal from judicial review. And that's not going to work. But at least I can say, hey, it looks like at the point of filing this in 2010, I found out that there is a way to get review on an issue where there's just no what they call ordinary remedy at law. So here we have, I'm still pushing this argument because I've started to realize that my original argument for judicial review is going to fail. So I'm sort of mutating this appeal into a completely new sort of case, which you cannot do. Appellate courts are there to review the decisions of the lower courts. They're not there to just kind of let somebody argue whatever it is they feel like arguing and plead for their intervention just on principles of fairness and equality. You have to start your case in the lower court, and then if something goes wrong, address what went wrong in the higher court. I'm not doing that here. What I'm doing is I'm starting my case in the lower court, and then I'm going into the higher court, and I'm basically inventing a completely new case with a completely new remedy, which is not something that they allow. The Supreme Court stated that they could issue a writ of mandamus to compel the performance of an act which the law requires. All of this is true, and they do eventually do it when I bring it to them appropriately. But they're not going to do it in this case because this is an appeal from a judicial review denial. So this is a valid argument, and I will bring this up later, probably a year from the time of this particular brief, but it's not going to happen now. Argument in support of insufficient evidence to issue. It's appearing that the district court stated without details the decision to support the Secretary of State's argument, and no hearings or trials have been conducted. So I'm saying the same thing it looks like here. The law delegates the authority of issuing fictitious addresses to the Secretary of State, which is true. This other law requires that specific evidence showing that a person is a victim is required, which is true. I'm citing the second law here, which is the one that contains an enumeration of examples of specific evidence that could indicate a person is a victim, which is also true. So these are the two laws that are clashing, 217.4622A and 217.4624. These are the two laws that are inconsistent. They intersect in a way that makes no logical sense. They're a contradiction. Next here we have me asserting that the legislature elaborated on the enumerated examples of evidence with the phrase that an adult, child, or incompetent person has been a victim, Those 4 words there are key because it requires actual victimhood, not potential victimhood, because it wanted to make certain that a mere record of conviction or protective order was not sufficient, because the conviction or issuance of a protective order had to be specifically indicative that an applicant was an actual victim. That's what I've been pushing, and that's what I will continue to push, and that's what leads to the publication Falcone v. Secretary of State. Next we have my argument, or the actual government's argument, that the law authorizes the issuance of a fictitious address when a protective order is received, and that it would only make any sense if protective orders were accompanied with transcripts of the hearing, admissions of guilt, police records, or something supporting that this particular protective order was based on the fact that the person who asked for it was an actual victim, not somebody that is a potential victim. That's what I'm trying to state. The next assertion here is, and now this is the problem. So this statute 33.020 subsection 1 is the problem statute that kind of throws everything out the window. This law illustrates how clearly and easily a protective order can be issued to a person whether or not there is actual evidence that they're a victim. Because pursuant to that law, the court is authorized to issue protective orders when, quote, there exists a threat of domestic violence, unquote. This phrase is the source of all of the problems in my case. The legislature did not think this through, and this is what created all of the problems associated with the fictitious address and the protective order hearing. Because it is possible for somebody to get a protective order when there is just a threat of domestic violence, there is no way to know for sure if somebody got a protective order because they were actually a victim or because they allege that there's a possibility or a threat that they might be a victim someday, possibly in the future. The purpose of those protective orders is to prevent domestic violence from occurring, and that does not necessarily require proof that domestic violence has occurred. So all of these arguments are wonderful arguments, but I brought them on appeal from a decision made in a judicial review action, which is not going to work. And I hope that my viewers learn from my mistake here. You can't just bring issues to the Supreme Court that are valid. You also have to bring those issues to the Supreme Court properly. If you bring them valid issues improperly, they will not give you the relief you are requesting. Next, we have an assertion from me that because protective orders are granted when there is a threat of domestic violence, then granting fictitious addresses based on the mere issuance of a protective order sets a chain of precedents whereby essentially any fictitious address is granted because not, there's an actual victim as the law requires, but because there is a threat. So it basically kind of shoehorns the fictitious address program into an extension of the protective order process, which is not what it's supposed to be. It's supposed to be a completely separate remedy that's available to actual and real victims, not just people who are claiming they become one. Next, we have the case that I'm citing, which is my lower case, the lower court's child custody action that I'm citing here. My ex has utterly failed to even remotely indicate that I was a perpetrator of DV, and it's important to note that had I been found to be a perpetrator of DV, the court would not have had the authority to give me physical custody of our son. And that is mostly true, but not completely true. There is a law in Nevada, and that's the law right there, I'm citing it, NRS 125C.230. By the way, guys, I think this is the first time I've aggressively cited to law in any filing that I've ever made. This particular filing is, for the most part, riddled with citations of statutes, rules, and case law. I'm doing the right thing here. I'm doing what you're supposed to do. So this law here, 125C.230, is a statute in Nevada that forbids a court from awarding physical custody to a perpetrator of domestic violence. I actually need to clarify. I shouldn't have used the word forbid. What it does is it creates they call this a rebuttable presumption, and I put the little air quotes up there for a reason, because those two words mean something very specific in Nevada law. I'm not just using the dictionary version of those words. Rebuttable presumption that I should not have physical custody of our son. So what that does is it sets you up so that you do not go to court on equal footing. The presumption puts it so that you go to court where your ex is presumed to get physical custody and you're presumed to only get visitation. And if you want to change that around, the burden is on you to show why, even though you are a perpetrator of domestic violence, you should still be able to get physical custody. So it really does change, I guess you could call it, the playing field. I hate to refer to this stuff with that kind of gamesman terminology, but it's instead of leveling the playing field, it skews it against you because you've been deemed a perpetrator of domestic violence. And there are quite a few common ways that attorneys get around that, where they rebut the presumption. One of the most common ways that they do it is they just point the finger at the other side and they say, hey, look, they're also a perpetrator of domestic violence. Even though my client punched them in the face on Tuesday, they kicked him in the groin on Friday. And so since they're also a perpetrator, then we should be able to rebut the presumption, and magically it no longer matters because we're both guilty of committing DV. The other common way is that they will point to other problems the other parent has, like they might be a drug addict or they might be a criminal of some kind, and so they might say, hey, okay, fine, so there's a presumption that we shouldn't get physical custody. However, we're going to go ahead and rebut that presumption because they have all of these other issues that are much worse. And there's all kinds of other ways that they go about doing it, but the rebuttable presumption is a very a serious thing to go up against when you go into court. You're not going to be going to court on equal footing. You're going to be going to court in a very disadvantageous position, and it's going to be on you, the person who has been found to have committed DV, to do all of this work to try and just get things equal again. It's very difficult, and I think for good reason. Parents who commit DV have usually an unfortunate way of looking at the world. Being able to commit that kind of violence against a person that you love is not normal. It just isn't. And so I assume that the legislature has considered some kind of evidence or studies or psychological input. I should say input from psychologists, child psychologists specifically, that is kind of backs this idea that a parent who commits DV is a parent who should not have physical custody, not just because they should be punished for what they've done. It's not really about punishing at all, but more so because of the likely mindset that they have, the likely way that they approach parenting, the likelihood of them continuing to commit DV on subsequent partners that they get into a relationship with, etc., etc. Let's scroll down. Here we have an assertion that legally my ex is only entitled to a fictitious address if sufficient evidence indicating that she is a victim exists. Legally, if I am not entitled to know where my son resides, then I am not entitled to have physical custody of my son. Again, that's mostly true, but not because of the rebuttable presumption phrase. It is possible for somebody to have committed DV and to still have physical custody of the child for all the reasons that I stated about 10 seconds ago. The government and the court should resist the temptation to offer such a degree of protection to a person at the cost of another, against the intentions of the legislature. The moral and social implications of hiding a child's residence from a law-abiding father or mother should not be taken lightly. And this is kind of general principles of fairness, and the Supreme Court does kind of convert this into a legal argument for me later on. What they do is they cite my constitutional right to parenthood. So I should have probably done that rather than just use these nice sounding phrases. But at the time that I prepared this brief, I really didn't know how important it was to cite to authority. Next, we have here a conclusion. Therefore, I request that the court reverse the decision made by the district court and order the Secretary of State to revoke my ex's fictitious address. And I further request that the court should rule that the evidence filed with her application does not prove that she perpetrated that. Oh, this is wrong. That I did not perpetrate DV upon her, etc., etc. Let's go on down to the section here. It's basically me saying that the fictitious address should be canceled and I should be allowed to know where she resides because I need to be allowed to know where he resides, our son. Since there's a defect in the law and the statutory mandate has been found violated, I'm requesting that the Supreme Court issue a writ of mandamus. Again, you can't do this. If you want a writ of mandamus, you have to file a petition for writ of mandamus in the Supreme Court. You can't just do this with an appeal. Suspension of NRAP 46B. The court has suspended a rule of appellate procedure 46B. Oh, this is probably the rule that requires an attorney to put some, what do they call it? It's a certificate that they have complied with the formatting. That's what 46B is, I think. I'm not sure. I'm not going to go ahead and look at it now because it could change in the future anyway. But lawyers are supposed to include the certificate that says this brief contains this many words, this many pages. I'm doing it in this font. And, it's just a way for the attorney to swear under oath that they have read the formatting rules before they prepared and filed their brief. It looks like this is my verification, which just indicates that I have reviewed this and it's based on my personal knowledge, and it's also under penalty of perjury. Certificate of service, yeah. So this basically confirms that I unstapled those other pages because this page here is that original self-help form, but it's the last page. So like I unstapled this packet, stuffed my stuff in the middle between the first chunk of pages and this last page. Here we have the certificate of service, which indicates that I mailed this document to, wait a minute, I didn't even name it. Okay, so there's supposed to be like the names and addresses of the people that I mailed it to, and I didn't even fill it out. It's just blank. Anyway, the government's lawyer should be listed here with the address. So it should say something like Charles Wayne Howell at a such and such address, Carson City, Nevada. So I didn't do that right either. Okay, here we have the notice of no intent to request transcripts. So normally when you file an appeal, you have to put together a transcript request form when you want transcripts. And that's a way of you communicating to the Supreme Court that you are in the process of getting transcripts from the lower court. And the notice or the transcript request form contains some details in it, like the documents, the transcripts that you're requesting, the specific dates of the hearing, and the name of the court reporter that is going to be preparing those transcripts. Those are in the transcript request form, and the importance of that is to keep the Supreme Court apprised as to what you are doing to litigate your appeal in a timely manner. And without the transcript request form, they have no clue what you're waiting on. And it seems to me to just be a way to keep the Supreme Court in the loop and the court reporter, to keep them in the loop as to what's going on with those transcripts. I also think it might be an opportunity for them to provide transcripts to the Supreme Court directly without giving you an opportunity to alter them or meddle with them. If you have transcripts in the lower court, they often will just transmit those up to the Supreme Court, and then you won't have to ask for them with a transcript request form. But not everyone does that, and it's very expensive to have transcripts prepared. So most people don't prepare transcripts for fun. They prepare them if they absolutely need them. And one of the times when you'll absolutely need them is on appeal to the Supreme Court of Nevada. The notice of no intent to request transcripts is just the other side of that same coin. And you file this particular document when you don't want any transcripts at all. And it's a way to communicate to the Supreme Court that I'm not going to file the transcript request form because I don't need any transcripts. It tells them very specifically that you know that that form is required and that you are not going to file it because you don't need any transcripts. That's why this is a required document. This is not me just being courteous to the Supreme Court. If you're not going to file a transcript request form, you need to let them know by a notice that you're not going to file one because you're not going to ask for any. Statement of notice: there having been no hearing conducted in the lower court, there are no transcripts for me to have prepared, which is true. You can't get any transcripts if you haven't had a hearing. And in this particular case, I didn't get a hearing. It was just denied on the papers. So I'm letting the Supreme Court know that the reason I'm not asking for transcripts is just because there are no transcripts to be had. Next document: notice of change of address. I am letting the Supreme Court know that I have moved. Just like in the lower court, you need to file this in any other court. And the Supreme Court of Nevada needs to be appraised of the fact that it moved just like the district court does. Oh, by the way, this document is a crucial document. I like to mention this every time that I come across one because I think people might think it's just me letting them know that I've moved and that's all it is. But no, it's much more than that. If you don't let them know that you've moved, somebody can mail a document to your old address, and that is treated as having been served upon you even though you don't live there anymore. I talk about the importance of understanding this in a video that I dedicated to the topic, and that video is titled Notice of Change of Address. Here we have the order directing a response from the Supreme Court of Nevada. It's probably from the Chief Justice. It is. So Chief Justice Michael Douglas, he's now retired, but at the time he wasn't. He is entering this order directing the, let's take a look here. Based on his review of the civil proper person appeal statement, he's concluding that a response is warranted. He is ordering the respondent, which is the government, to prepare, file, and serve a response to my opening brief, or whatever you want to call it, that custom document that got stapled together, within 15 days, including points and authorities, addressing the issues that I raised in my appeal and the arguments that I made. The respondent, or the government's response, shall not exceed 10 pages, and the attorney certificate required by Rule 28.2, and the response does not need to contain a table of contents or table of cases and statutes, and or any of the other authorities required by Rule 28b. The respondent may cite to the record on appeal if they want to, but they don't have to. And I don't know what else he says. Appellant shall have, if I want to, I can file a reply to the government's response 5 days from the date that I receive it, and my reply cannot exceed 5 pages. I like to call this a screening order. So normally when an attorney files an appeal, it triggers a process where the opponent has to respond within a certain amount of time. The Supreme Court does not, pipe in and say, hey, you need to respond. The attorneys have to follow the rules of appellate procedures and determine, at what point something needs to be filed. But when a self-represented party files an appeal, it's different. Instead, it goes through a screening process where the adversary in the appeal can just kind of sit back and wait and see what the Supreme Court says. And the Supreme Court will review the filing, and they'll determine on occasion, sometimes, that this particular appeal has serious jurisdictional flaws, or that the arguments made don't really warrant any kind of response because there are basic principles of review that allow them to render a decision right then and there against the appellant. And so they do this to kind of save people time, stress, and money, because a lot of times a self-represented party won't know what they're doing, and they will file an appeal that has no chance of going anywhere. So rather than allow the attorneys or the adversary to be stressed out and financially harmed by having to, respond to this appeal when they've already won their case in the lower court, the Supreme Court likes to screen these appeals, the ones that are filed by self-represented parties, to determine whether or not they have any merit. So in this particular case, my particular appeal has been deemed to have merit. It doesn't mean I'm going to win, but it's been deemed to have raised issues that need to be addressed, and so they are going to allow this appeal to proceed, and part of that process is directing my opponent to file a response. I don't know if they still do this to this day. A lot of these rules have changed, but I suspect that they do. I know for sure that they do it on writ petitions, but actually, now that I think about it, I think they do that for everyone on writ petitions, even lawyers. So I don't know. I could look into that later. Maybe I'll give my viewers an update. But at the time that I filed this, anything that was filed by, or any appeal that was filed by a self-represented party had to go through screening. So here we have an order directing transmission of the record. Now, it looks like the other Justice Parraguirre, is getting involved here. I'm not sure if he's... Okay, so it says he is the Chief Justice. Let me check really quick on the other guy. He's also the Chief Justice. So there must have been some kind of switch between the Chief Justices that occurred here, because we have a new Chief Justice, and this is Ronald Parraguirre. He's still on the Supreme Court today, and he is directing the record, or he's directing transmission of the record from the lower court. So he's indicating that he has reviewed the documents on file, and he's concluded that complete review of the complete record is warranted. I think at this point, I don't know what's going on here, because it doesn't indicate that he's reviewed my opponent's response at this point. So this might just be another routine filing following the order directing a response. But what this does is it orders the clerk of the district court, which is the lower court, to put together I don't think they call it an appendix. They just call it the record on appeal. It's very different than how it usually works. But the record on appeal contains every single filing in the lower court. And that's something that I think people need to really key in on, because you can't really put together your own evidence or your own set of documents that you want them to review in the context of sort of proving your case in the Supreme Court. You're constrained or confined by the record on appeal in the lower court. And it's very important to understand why they do this. The reason they do this is because when you go to the Supreme Court, you're trying to argue that there was a mistake that was made. And if a mistake was made, it would be based on whatever evidence was before the lower court at that time. It wouldn't be based on something new that the lower court has never seen. That's not a mistake being made. That's just you saying you should win for other reasons, for things that had nothing to do with the lower court's decision. One of the things I mentioned is that this is not very regular. It's true. Lawyers don't expect the entire record to be transmitted to the Supreme Court. When lawyers are involved, they prepare what's called an appendix. And eventually, I am going to have to prepare an appendix when I start to file writ petitions. But because I'm a self-represented party, because I'm not a lawyer, and this is an appeal, I'm not required to prepare an appendix. And in fact, if I remember correctly, the only way I can do that is by asking for permission from the Supreme Court. If you don't ask for permission and permission's not given, then they just treat you like a self-represented party, and rather than have you prepare an appendix, they just transmit the entire record up. An appendix is portions of the record, only the portions that are relevant to the appeal. It's actually less of a strain on the legal system, because they don't have to review each and every single filing and transcript in the lower court. They only have to review the filings and transcripts that are very specific to the issues that have been raised on appeal. So appendices are much more efficient, but because I'm not an attorney, I don't get to prepare an appendix, and they instead will direct transmission of the entire record, every single thing that was filed. Your state might be different. Be careful. Some of these states out there might not give any kind of leeway to self-represented parties, and you may have to prepare an appendix even though you're self-represented. In Nevada, you don't have to, but in other states, you might. I should clarify that. In Nevada, you will have to prepare an appendix if you're not filing an appeal, and what I mean by that is a writ petition. If you want to learn a little bit more about that, you can watch my video, Writ Petitions. Order granting telephonic extension. It looks like somebody asked for a telephonic extension. Most likely, okay, the government. So the government asked for a telephonic extension. This is something unique to the Supreme Court of Nevada. I don't think any of the other courts in our state do this, but in the Supreme Court of Nevada, they have a rule of appellate procedure which allows an attorney, I don't think a non-attorney can do this. Maybe, I'm not sure. But it allows an attorney to just phone in and call the clerk. And the clerk of the Supreme Court can give them an extension on when something is due without even asking the judge. In fact, if you look down here, the clerk of the court's entering an order in this case. This clerk, Tracie Lindeman, she's not a judge. She's just a clerk. And she, just like that, has entered an order giving an extension to the government. This is actually very commonplace. It happens in almost every appeal. Both lawyers will take advantage of this and get telephonic extensions, but they can't do it in an infinite amount of times. If I remember correctly, they can each only do it once. And if I remember correctly, they can each only ask for I think it's a 5-day extension, but I can't remember for sure now. So the clerk of the court is very limited as to what she can give a person who is asking for a telephonic extension. It's only a certain number of times, I believe just once, and it's only a very limited number of days. After that, you can get an extension, but not from the clerk of the court. You have to file a motion, and the Chief Justice, has to rule on it. Here's a letter that I have sent in to the Supreme Court. Please don't send letters to a court, with rare exceptions. Like if you're dealing with, I think they have a few cases where they will accept letters. A subpoena, like if you're objecting to a subpoena, or if you are, I think they do it in probate cases involving like heirs to a deceased person's estate, they'll take letters in those cases. But in any other situation, especially if you're the party to a case, sending a letter is really cheesy, and I just don't recommend doing it. So here I am clarifying something to the Supreme Court. I apologize for attaching my opening brief to the previous proper person appeal statement. I was confused and did not realize that it should have been done separately after the court approved my proper person appeal. Oh. Okay, now I know why that weird pattern of orders came through. There was that one order directing a response, and then there was that other order directing transmission of the record. I get it now. So it looks like my proper person appeal statement should have been very similar to the docketing statement that's filed in a normal appeal. And it looks like that, after being reviewed, would pass screening, and they would do that first order, the order directing a response. And at that point, I would probably file my brief, and the government, or they would probably review my brief, and then if they still felt that the case should go forward, then they would probably enter the second one, which is the order directing transmission of the record. It's probably what was supposed to happen, but because I didn't know, and I kind of lumped it all together in that first document, they just entered both of those orders, so it got through both screenings simultaneous. Yeah, try to follow the process. Don't kind of invent your own way of approaching this, because it could backfire on you. Anyway, it says here, I did not realize that I should have done those separately, and the court approved. After the court approved my proper person appeal, I made a copy and sent it directly to the court for filing and to the Attorney General for service. This copy is the same as the one attached to the civil proper person appeal statement. For all intents and purposes, I suppose that should be considered the original. I also sent a copy of the affidavit of service to the Attorney General, advising them of a time limit to respond. It appears to me 30 days is a time limit. So maybe this was, and I don't understand. Maybe this was entered with me not having received those orders from the Supreme Court yet, and I didn't know the amount of time that the government had to respond. But where I'm probably pulling the 30 days from is the rules of appellate procedure. That sounds like it's possibly right. I don't know for sure. But I'm not going to go ahead and speculate, because there's no point. The Supreme Court of Nevada entered an order giving them a time limit, so why bother looking into where I got that from? Oh, so this is the opening brief that I filed separately? Well, I'm not going to go through it because we've already gone through it. Okay, so I'm going to just go ahead and basically just stop at this point, because this brief was the one that I stapled between all those other pages that we went over as the first document that we looked at in this case. Going into the aftermath, I filed a number of documents. In this case, it looks like at least 4 documents that I filed, 3 documents that the Supreme Court filed. But the 4 documents that I filed were free filings, so I incurred $0 in costs. The government didn't file anything in this case, so they have so far incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have had to review some of these documents. Let's go ahead and lump those orders all together into 5 minutes. The order directing a response, the order directing transmission, and the order granting telephonic extension. They probably would have just put those into their computer system and not even bothered to really look into it much more than that. They're just kind of letting the government know about where they are in the process. So those 3 documents, 5 minutes. The letter that I filed, I don't even know if I want to give it 1 or 2 minutes. They would have probably ignored it. So let's just leave that out as negligible. The notice of change of address that I filed, we'll go ahead and give them 5 minutes on that to update their computer system as well, because they're going to need to know where they need to send documents to. That does matter. So we're at 10 minutes so far. The notice of no intent to request a transcript, I'm leaning at 5 minutes for that as well. Maybe even less. Let's just give that one, let's treat that one negligible, because they have nothing to look into if I'm not asking for any transcripts. Maybe they could look into, no, because there was no hearing. So it's one of those simple documents. So we're still at 10 minutes. Then we have the civil proper appeal statement. Now this contains my entire brief. Now this would take them a little bit longer to look through. I'm not going to say a whole lot longer. So we're at 10 minutes so far. I think it would be reasonable to say that they probably reviewed that entire thing in 20 minutes, because once they see that I'm trying to ask for a writ of mandamus, they can probably piece together in their head a very quick way to shoot that down just by saying, you can't do that. He hasn't filed a petition for writ of mandamus. But I don't want to make it something cheesy like 5 minutes or negligible. I think 20 minutes is reasonable. Adding that with the other 10 minutes, we have 30 minutes in attorney fees at a rate of $250 an hour. That's going to come to $125. As with my previous videos, if you have any questions, you can post them down in the comments below, and I will see you guys next time.